we've actually wasted about 6 months in applications, my lord. This is not to say that the applicants or this person do not have the right to make those applications. I appreciate that it was all within his right. Our argument is that those several applications affected their trial. I mean, the quickest or a quick trial of this matter. We started disclosing this matter right from what was remaining were basically about 5 statements. This is whom we thought we at risk harassment and compromise, among others. Basis, we filed an application, sorry, my lord, an application for protection the deponent. That application, the land State Attorney Joseph Chomuhendo. Examine is, if not 3, almost. Lord, was it and speedy trial, not disputing fair trial, decided to that application. Such as protection of witnesses is part of the fair trial. Protection of our witnesses for the sake of having this matter After withdrawing our application, we fully disclosed the remaining 5 witnesses. The statements for those remaining 5 witnesses. Defense. We intimated to them or to this court, my lord, that we are ready to have the matter start. Defense brought another issue that we had to agree to some issues or facts which prosecution never had. And they were raising, but they were not specific with those issues. And because of that, my lord, made an order. The prosecution brings or presents its witnesses. What are witnesses, my lord? We brought 2 of them that time. Although for their statutory reasons, they were not in this honorable court. But some were very close to reach of this court. The applicants spoke their accused persons. Filed an application for human rights enforcement. Against room host Kenneth Gaba and 3 others. My lord, on the 11th of June, this court issued about schedules. Directives on schedules that application. And my lord, the main case was began to the same date of the hearing of that application on the 30th of June, 2026. My lord, of June 2026, fixed their applications for A1 and A2. That is application number 213 of 2026, and also That's application number 0698 of 2025 for A3. My Lord, the reason why these applications were fixed is because counsel for the applicant stroke accused persons had requested the court previously to have the same disposed of. The demand was to dispose of the said bail applications, human rights enforcement application. Then they also asked for facilities to be availed both at court and in the prison. That is the reason why, my Lord, the two bail applications were fixed. Also, in order to address the issue of facilities,
Wait, how old is the new hire?
I don't know, but he literally uses Excel.
his persons brought to court, prisons. I'll come to that later, my Lord. Let me first finish up with the issue of the application. My Lord, on the 30th, issued the directives the respondent their reply by 1st of July 2026. And that the applicants make their rejoinder on the 2nd day of July 2026, if any. Then it was fixed today for hearing at 2 p.m. Lord, just to remind this court, the accused persons, is that on the 30th day of June 2026, counsel for the applicant stroke accused persons that they were ready to receive directive or directives on or schedules this application was fixed today, or the two applications were fixed today. My Lord, this application, that is 213, Okay. It was not solely filed by Senior Counsel Martha Karua, Counsel for, I think it was filed by so many. It was a joint application, if I'm remember very well. Okay, Council the firm for council, Senior Council was part, but there were other firms which worked very hard to file this application. Council Tugume on the 30th of June 2026. Let me just make it clear. Neither counsel for the applicant nor applicants expressly informed this court that this matter wouldn't take off today. I appreciate that the issue of representation came up, but they were not the point that this application would not take off. And as a result, my lord, the respondent complied with the directives. We filed our response by 1st of July 2026. My lord, as it has been a culture between counsel for the applicants and as counsel for the respondent, we have been having a cordial relationship in terms of service. Such as ethnics, when you file an ethnics, the other party is deemed have been served. We have been having that cordial relationship that we normally serve the hard copy of our pleadings. So it is because of that relationship that we thought we could serve counsel in this matter. Our surprise, they say they cannot receive service because they had no instructions. We hadn't seen anything on record for withdrawal. Basis of the respondent serving the applicant's counsel. My lord, we came today, respondent is ready to have this application prosecuted. My Lord, just this one is normally the applicant having the application prosecuted. My Lord, before I go to the tail end of this application, I just wish to say a few things. The applicant, the issue of that he was charged with misprision. He was arrested by the Uganda. We are not aware, my Lord. Not aware Senior Counsel Martha Karua, whom we respect here, was deported and declared persona non grata by General Muhoozi Kennedy. The representation of the applicant's stock accused persons, and we shall respect that because it forms part of his constitutional rights. That he sympathized with his legal team, and as such, relieved them of their duties. I hope I got him very well from that.
And I mean, never do crunches if you're over.
And is willing to stay in prison. Submission as respondents. The applicant is anxious to leave prison to be prosecuted. Inclined submit that this court has powers under Section 37 of the Education Act. It is a party before it. Lord, our remit is under Section 72(2)(a) of the Education Act. I mean 17(2). Section 17(2). Section 17(2)(a) of the Judicature Act, Cap 16, have, my Lord, this application dismissed. This application, my Lord, can always come up. Because as respondents, we are not aware of the application in respect to his legal representation. So it would be hypothetical and speculative on our part, my Lord, start the merits of that application at this level. This dismissal, my Lord, is intended to curtail emanate from of the legal process. That as respondents, we don't believe in the applicant's right to apply for it. We believe in that. And that's why, my Lord, we work tooth and nail to ensure that we file our response by 1st of July 2026. Under pressure to ensure that we Article 28. Trial, my Lord. 28 of the Constitution, my Lord, in respect to speedy trial. So, my Lord, we so submit. Melody just had something which I had forgotten about. We received a copy as respondents of a letter from prisoners. Yes, we got a letter from the registrar attaching a response from Uganda prisoners dated 29th of June 2026. So this letter is to the effect that the prisons authority have granted and you are going to provide facilities. The applicants, stroke accused persons, which they initially prayed for. Briefly, the letter which we talked about, which Colonel retired Dr. Kizza Besigye talked about that he filed, whereas the respondents are not privy to it, so we do not know the details of the said letter. Nonetheless, we reiterate our earlier submissions.
Yes, just a few responses. Understanding of the process. In respect of is not in line with the law. Prior the seriousness that has been so much talked about. Right? Stages, especially is a serious stage. Regarding disclosures, the point was made here. Reason talk about full disclosure. No, the whole case, as you have all the information, not parts of the information. Only able to know whether we have all the information on June the 1st. continued piecemeal all the way. Politically, trust, an essential element, the disclosures is in electronic documents. Videos and audios. Which, regardless of when they were passed on to our council, up to this day, as we stand in court, never received even the Mohad. Facilities to do so was given in this court. That first day of June. Was supposed to communicate those instructions to the prison authorities. Best of my knowledge, instruction about facilities being accessed in the prisons to view these things has never been communicated by the deputy registrar of the prison. This was missing. The deputy registrar wrote, the letter was read to us, provision of time in weekends, public holidays, accessing. Then our lawyers heard what was communicated to them. They came back to the deputy registrar, informed about the problem that still existed. is a letter in court with the prosecution. They can help courts to read to us that facilities have been allowed in the prisons. We use what I used.
There are two letters.
One from
Prison.
Keto didn't touch it. Intermittent fasting didn't touch it.
(2026). 29th of June, 2026. My Lord, is addressed to a Deputy Registrar of Criminal Division, Kampala. My Lord, and it is in response to requests presented by lawyers in the criminal section case number 335 of 2025, Uganda versus Capt. Dr. Kizza Besigye and others. Reference is made to Kampala High Court Criminal Division Deputy Registrar 18th of June 2026. Reference guidance on requests made by lawyers in criminal session number 335 of 2025, Uganda versus Capt. Dr. Kizza Besigye and others. 2. Below is the response to the respective requests. The lawyers of the accused persons be provided with unrestricted access to the prison facility from 8 a.m. to 6 p.m. to ensure preparatory meeting time as required for purposes of taking a full account of the events and identifying the potential witnesses for accused persons and attending the facility with such people from time to time. Response: access granted from 8 a.m. to 5 p.m. B. Lawyers and the accused persons be provided with an interview room free of any officers of the state and which is large enough to accommodate 15 to 20 lawyers and any assistants to ensure that the advocate, client privilege, and necessary confidentiality is accorded. Response: the spacious room large enough to accommodate 15 to 20 lawyers and any assistance is available and will be provided. Second response: the client advocate privilege of confidentiality will be accorded with the prison officer being in sight but not in the meeting of the ongoing interaction as provided for under section 63.3 of the Prisons Act, Cap. 325, regulation 54.3 of the Prisons Regulations 2012, and chapter 38, paragraph 8, subparagraph 5C of the Prisons Standing Orders, part 2, 2017. C. Lawyers of the accused persons be permitted to bring in and take out of the facility on each day of consultation. A. Projector and whiteboard stroke background. Response. This will be provided. 2. Laptops, mobile phones, ear stroke, headphones, and mini sound speakers. Response. Laptop, ear stroke, headphones, and mini sound speakers will be provided. B. The mobile phones are not granted entry into the prison, but can be kept by the outside visitor handling office where the lawyers can access them with ease. Mobile phones are key prohibited items in prison as per Chapter 45, Paragraph 2H of the Prison Standing Orders 2017. 3. Internet connection, which is secure to facilitate on-spot research. Response. This is not granted in the lawyer's interaction room, but we shall avail an alternative nearby room equipped with internet accessible to only lawyers for research on need basis. B. An IT expert of the accused person's choice to assist in defense preparations be allowed to prisons with lawyers of the accused persons. Response. This is hereby granted, but upon full identification. E. A forensic examiner of the accused person's choice to assist in defense preparations be allowed access with the lawyers of the accused persons. Response. This is hereby granted, but upon full identification. Lawyers of the accused persons will be allowed access to the facility with all case files, flash drives, notebooks, pens, statute books in hard and soft copy as may be deemed necessary for effective consultation. Response. Grant of access is hereby accorded to all case files, notebooks, statute books, big crypto ballpoint, pens, and flash drives containing only electronic evidence and soft copies of statutory books. G. Permission to access the facility with the necessary meals and refreshments for those attending the consultation sessions. Response. The refreshment that is packaged water is hereby granted for the lawyers. The accused person's refreshment will be got from their internal stock, while the lawyers are at will to have scheduled meal breaks, as the accused persons also go back to their residence for their internal. H. Lawyers representing the accused persons will be granted access with the required confidentiality to the accused person at court before commencement of every court session. Response. The interaction with the accused person, with the accused before court commencement is granted, but subject to security assessment and controls. Most obliged. Continue for Commissioner General of Prison.
So, I wrote as you had that letter 4 days ago. Was explained during the crisis. And the rest is some progress. We are able to assemble a legal team. Hopefully, that letter will be made available to us. Is it possible to
Yes, it was copied, my lord, to the Defense Council. And yes, and state attorneys.
the surface I could hear areas resolve the question of PPP continuously refers to speed and try, keep trying. Says they withdrew the strong hand of application for witness protection. As that if tried, their witness risk which they were trying to protect. Can you imagine they are seeking to protect officers, and they are now worried about their safety. Where does that leave our lawyers? Threatened like the senior most military officer. There's needed protection. And imagine what we are facing. Those who need protection. General laws. Nigeria in New York. Fact is only one element of the preliminary. All these others are part of that. Facts, if they are none, it's just recorded that they are none. But the legal requirement that if they are agreed facts, agreed documents, if they are in the memorandum is worked out and signed by all parties. Conclude preliminary hearing. When these other matters are not being dealt, including this application, including the access, the disclosures, preliminary hearing, trial was supposed to begin on 11 June. This letter, which is now giving access, is on 29 June. And there rests our concern. Come here on 11 and face a witness before you access the disclosures. surprised to know that comments in the matters of our application for human rights is not a party. Maybe the reality is that he is actually a party. The Attorney General introduced prostitution when he was introducing was a slip of the tongue. Prosecution is telling us what happened back here in respect. These proceedings. Regarding the bail, really interested as we are in getting freedom, liberty. I haven't seen him since. I don't know whether he's in hiding. Council, Oola, the few lawyers who were here getting the impression instructed to continue prosecuting these matters. Was to be a wrong impression. The lawyers before we came here, the court cells down here. And our clear understanding was that they were coming to raise their situation. Indicate how the team has been decapitated, rendered unfunctional. You are decapitated. If you are decapitated, you can refer to the body as still able to continue doing something. when it has lost its head. Because the body functions as one. Some parts are not as critical as others. They lose a finger, they even lose a hand. When you are decapitated, the head is removed. During that period. So, if by their presence, they talked very clear and loud and important in my presence and very I think one said that it was even not about before whether it was in they are none. It's just recorded that they are none. But the legal requirement that if they are given facts, read documents, they are in a memorandum worked out and signed by all parties. Conclude preliminary hearing. When these other matters are not being dealt in this application, the access, the disclosures, hearing, and the trial was supposed to begin on 11 June. This letter, which is now giving access, is on 29 June. They arrest our concern. We are expected to come here on 11 and face a witness. Or we access the disclosures. Surprised to know that comments in the matters of our application for human rights is not a party. Indeed, the reality is that he is actually a party. The Attorney General introduced the Constitution, he was introducing he thought it was a slip of the tongue. Now, prosecution is telling us what happened that year in respect proceedings of that. The day if we were really interested, as we are, in getting freedom, liberty, under threat, we haven't seen him since. Whether he's in hiding. If counsel Gune, the few lawyers who were here to the impression that they were a team instructed to continue prosecuting these matters. It would be a wrong impression. We met the lawyers before we came here. The court says, come here. And our clear understanding that they were coming to raise about their situation. Indicate how the team has been decapitated and function. You are decapitated. If you are decapitated, you can refer to the body as still able to continue doing something when it has lost its head. Because the body functions as one. Some parts are not as critical as others. They lose a finger, they even lose a hand. When you are decapitated, the head is removed. Build respiration. So, if situation was created, that by their presence, they talked very clear and loudly in the court in my presence of hearing, of their dilemma. one said that he was even not out sure whether he could report. That is simply whether it's one or two or three, they function as a body, was rendered dysfunctional. Now is how to deal with it. This comes with they knew the truth, but there was no instruction. The response they was they have not communicated. Yes. I'm inclined to agree that does not. General Mugozi Kainerugaba is behind the arrest. This was the responsible for the arrest of and for the deportation of inclined to believe. That is why we find that application to foreign so that evidence is adduced, so that he is responsible, the respondent is responsible for the terror which we need to deal with. Regarding the recommendations, dismiss this very application. I think we've been very clear that we are very keen on bail. Indeed, these applications had been hard in accordance with the bail disposal regulations that are in place today. This crisis would never have arisen. Bail disposal regulations like the Constitution, bail guidelines for courts of judicature, practice, directions of implementation. Provide that bail applications should be disposed of within 30 days. our bail application had and dispose 30 days since we will not be here. As I pointed out in the case of our accused, Kenona, the application is of last year. So we are simply incapacitated act because of the reasons I have presented to court. We have challenges of legal representation and therefore of communication. We didn't receive your reply. We can't rejoin the reply. We are simply stranded. So indicated that our witnesses, at least one of them, under threat. They show one of their sureties. So I don't leave it to the court. Because of it, our sons
So now some minutes past 5. And deliver this ruling next week in case. And I'll deliver it to me, please. And I am ordering that the hard copy will be delivered to you in Luzira through Luzira. By 3. The second application.
For the prosecution, Thomas Jatiko, Assistant CPP, here together, my land friend Richard, Capt, State Attorney, George Bigira, Senior State Attorney. My Lord, we came ready to proceed. Question here.
After that, there is a letter of so that all of us were free to descend the event. But on the way, I'd like to bring to the as I speak, I'm actually making almost 3 years in detention. And here it is in my interest that this bail has to be possible. Bail is of 2025. Recall was first fixed for hearing in March. It was supposed to take place on 27th of January. Before that hearing would take place on 25th of January, a production warrant was produced. Rescheduling that the hearing will happen on 26th of February 2020. On 25th of February, a letter from the deputy registrar again went to the prison, which they received actually on therefore not handling. Every time that court schedule a hearing, I have to transport the sureties all the way from Oola to come and attend. And for those 2 occasions, the cancellation comes when they have already traveled. Yet this money I have to source from relatives, friends. Also putting into consideration that communication itself I access communication, manage them, that is out to my relatives and friends who could facilitate my lawyers and the shield. And he promised me to write to you, inform you. However, as I was entering here, when we are got here, I seek to information. One, was actually written to you, informing you of the same, requesting you to adjourn this hearing to the nearest date possible. The information I received that the resources that I needed to facilitate my sureties and to facilitate the lawyers to be present in court, finally in court. It's my humble prayer, putting into consideration the time this bill has spent before the Honorable Court, into consideration the time I've spent in detention, and putting on consideration very, very challenges that both me, my siblings, my children, and family are faced with, relying on other people. It will only be just for this Honorable Court fixed a hearing. Yeah, so that it can be disposed of and get to know the fate.
Why don't we have no objection to prayer? Applicant Captain Denise Oola for the adjournment to another date to enable him and his lawyer prosecute his application.
talking about the journalist of the same case. Off record now. Now, finish this matter. I have listened. Started by saying that when you are starting to talk and do listen, I will now go to the press. But if you don't know the language of God, we shall have to discuss. The moment like now I have a agenda. Honestly, the language of God is what has been at when we start reporting that the judge has run out of court, that one we shall discuss. The matter is at now, like now what really I'm saying, I'm communicating, is not part of the proceeding. Doctor, honestly, I have listened to you from day one, not only today. Even, I think in those incidents where you saw saying that the judge ran out of court, of which, honestly, we had agreed with petition. You can take all the photos as you want, but not here. Not when I'm entering, not when I'm going out. You want us, who are yet informed the public. But actually, so, I have heard my listen, if you want this was record. I listen, and when you conclude, I have said matters of gender and given a date. When you continue talking, and you go away, it means there is no way I can write right now. So, bear with me. But let us understand the process. What cannot happen. You have been here since I mean, it was now coming to 6. So, you are right that I must listen. There is no compromise from that. I have already said that people what you are saying. Right or fair trial, you can't compromise. So what we need is let us know the process. Starting with the place with the applicants, finally the public. Honestly, let us agree. We have, if I can tell you the struggle I have gone through, when they want to pick you for contempt of court, you can't do it. I have struggled, I have refused. Starting with Lutale, is she here? Not here today. People insisted that I order for contempt of court here. I refused. They took her to CPS. They came, I said, no. Reason? I was aware that she's the daughter, she's representing. As human being, I said, probably personal emotion cannot be talked about. What they are talking about is God. One of them can't say that the lady who was here and did what she did. I didn't. Judge, counsel, and no doctor. Because you said that some people were arrested for tomato. I was not there. The lawyers. That one you can't talk about it. You cannot think about it. You cannot think that the judge at least saved this William Lutale. propose them here in the court at CPS and refuse it. I have done other extra miles. With BBC, refusing to enter. I made here some things, but one, I around the relatives, around the people in the court. But that one, whether the press, whether the singing, cannot talk about it. Now, so let us just respect. I know the emotion, but let us respect. I'm not the one who these processes. Sometimes I say, if I don't interact with them, that was the persons I have talked with the prisoners, allow people to meet you. Allow people to interact. I have reached the point that even now, before you come, I told the lawyers to interact with you. Not I'm aware when you say they are child, they say it's okay. Interact with them before you come. With relatives here in court. But cannot be found. So, currently the public now, what do you lose here to wait after here and receive from outside? But if this court order is also possible pressure, I am provoking mystery, let it go. Don't charge people. Now is also blaming me for provoking this and look at the court. Now, the press now capitalize on my communication. Now, the news is there for what has happened as a process. But now, in-house, yeah, these are in-house things. And I have requested, I think I have met with the team in-house. Some problems have been solved. So, the challenges can be solved, but not as a battlefield. Not as a battlefield, but we can always discuss. I have several times forced the constitution to attend the meeting. Sometimes they say, no, we can't attend that meeting if they have requested facilities in the area we are not part. I said, come, let us listen. Okay. Now, as I conclude, as I am like that later, I think it is weakness, but since you have the challenge of accessing weakness, I'm going to direct the registrar prison to get a copy. So that they cannot access the weakness. Because it is a weaker than weakness. Get that later, detailing the facilities. Let them take.
Subscribe.
common knowledge that the office of the DPP is not privy to what happens in terms of action. And the office of the Director of Public Prosecutions under Article 1 of the Constitution is in charge of civil justice system. That, my Lord,